The officers have gone out.
My God, thank you so much.
They've got the bad guy. They got him in custody. So what happens now? They're arrested. They're booked. Now we get into the pre-trial and the trial phases. Okay, many important decisions about what happens to the defendant are made prior to trial, but after the complaint has been filed. And remember, there's two ways to file the complaint. The first is via an indictment, and that's what you see on TV a lot. The grand jury convenes and the officers present their case. They say, yes, you have probable cause. They authorize the indictment, which is the authority to initiate the arrest. The other way is through information. The document is called information, and that's what the district attorney files. There's case law. Somebody brought it up, I don't know which case it was, but that their due process rights were violated because they never got to present the case to the grand jury. So, Supreme Court of the United States, SCOTUS, said no. The indictment will suffice. So those are our two ways. The district attorney through the information, or the grand jury through the indictment process. Okay, now the hearing. Hearings such as before the grand jury, prelim, are held to determine probable cause. Explain that. If so, the defendant is arraigned. They enter a plea. At that time, they're told of their rights, and an attorney is appointed if they can't afford an attorney. Okay, so we have the arrest. They've gone through booking. Now, within 24 to 48 hours, they have to go before the court. And the court reviews the process to that point. Make sure that all due process has been afforded. They review the allegation, and then they ask the defendant if they like an attorney. If they say yes, one's appointed, they usually do it right there in the courtroom. Like we talked about the ways attorneys can be appointed, through contract or through the public defender's office. Now the attorney meets with the defendant every bit of maybe 2 minutes, where they scan through the allegations. They tell the defendant, we're going to enter a plea of not guilty. They're going to set dates, and then he'll meet with that defendant at a later time to review how they're going to prepare the defense. Okay? Enter the plea, they're informed of their rights, and usually an attorney's appointed. A necessary evil. Bail. Between bail and plea bargaining, those are my two toughest things I have to deal with, because I don't like either one of them. I cannot stand the idea that if you have enough money, you don't have to stay in jail while your case is being processed. If you have enough money to pay a bail bondsman, say you're being held on a $100,000 bail, rule of thumb is 10%. Nowadays, most bondsmen will go as low as 5%, but you're 5%. So you're still looking at $5,000 to secure that bond. And that's money you never get back. Whatever you pay that bondsman, that's their fee for taking the risk that you will meet all your court dates. Okay. Everybody understand how bond works through the bail bonds? Yeah. Well, if somebody understands it, then I'm going to ask somebody to tell me about it. If everybody gets it, then we're okay, right? Drake has his hand. You've done it. Raven, you understand it?
Yeah.
Can you tell me how bail bonds work?
So
You understand?
there's a bail for, like you said, 100,000.
Mm-hmm.
You go to a bail bondsman,
Mm-hmm.
and they'll take a percentage of the money you owe them, or that bail,
Okay.
and you just have to do your job to make sure to show up to your court dates, and you don't have to pay that whole thing, right?
Well, what happens if you don't show up to your court dates?
You get arrested.
Well, they issue a bench warrant, but what happens to that bail bondsman, the one that you put up the full 100,000?
Oh, you lose your money and you still have to pay the rest of it off?
You're going to lose your money, but the bail bondsman loses their money. That's where bounty hunters come. Okay, that's where bounty hunters come. So the bondsman says, I'll put up the $100,000 bail. I'm gonna charge you $5,000. That's my fee. You never see that again. They write out a check. The court holds that check for $100,000. As long as this person makes all their court dates without fail, it goes through the entire process, the court rips up that bond. Okay? They never cash that check. And the bail bondsman made $5,000 off of you. But if you don't show up, first thing that court's gonna do is run that $100,000 to the bank. And that bondsman is out now $100,000. Well, 95, because they got the 5 up front. So what do you think they're gonna do to you when they find you and they want their money? It's not gonna go nice. They will get their money one way or another. First thing they're gonna do is issue, the court's gonna issue the bench warrant for your arrest. If you're taken back into custody, the court may refund the money. May. But the bondsmen want to make sure. That's why they hire the bounty hunters. They go and find you, drag your ass back to jail, and you'll never see the light of day until your trial's set. So it's a big risk on these bondsmen. That's just one way that it works. Another way it works, let's see if they talk about it here. No. Or own reconnaissance. You're an upstanding citizen, you pose very little flight risk, maybe you have a good job, you have a family, you own a home. The charges aren't really that serious. The court will take a chance and say, okay, we're gonna release you on OR, but you're promising to come back on these dates as ordered. Yes. Now, another way, if you don't have $100,000 sitting in the bank to give to the court to secure your release, you can sign property. It's up to the court what they'll accept as a lien on a home, just depends on the amount. Usually it's your home or property. Okay, so bail, it's supposed to be fair. It's supposed to be within reason. Unfortunately, sometimes it's not. Okay? It just depends. Yeah.
So, from my understanding, I thought that the bail bond place, when somebody said you had to go get somebody out of jail, then you would tell the bond person, hey, I have my house, you know, use it as collateral, so that way you provide the money.
Sometimes.
Is that something that happens? Okay, because then when you said something about the court, I thought, oh, maybe that's going through the court and not through the bail.
No, the court will do it too. If you can negotiate through the court, you're better off because you're not paying the bondsman. Unfortunately, the court's real strict on what they'll accept and what they don't accept. Where a bondsman will take a Schwinn bike, a dirt bike, an ATV, your vehicle, your house and property, of course. But they'll negotiate more. They'll be willing to deal with you. But it's a risk. Okay, it's always going to be a risk, and that's why I don't like that. If you're wealthy, who gives a damn, right? You got the money, you don't have a care in the world. But if you're barely getting by, you have nothing to your name, a bondsman's not even going to want to talk to you. Okay, they're in business to make money, and if you can't put something on the table, they don't want anything to do with you. So you sit in jail. Prohibits, 8th Amendment, prohibits both cruel and unusual punishment and excessive bail. It says it right in the Constitution. What's excessive? Think about that. Let's talk about money. If we had to pay a fine, who here thinks $100 is excessive? Show of hands, please. $100. Okay, great. One. $1,000. Who thinks that's excessive? I'm sorry?
I don't think it depends on the citation.
Well, we'll get to that, but I just want to see the level of comfort when we're spending money. So $1,000, right? How about $10,000? Excessive, right? Okay, I think I got everybody. So we're drawing the line right at about $10,000. That's cashing in everything you probably own to come up with $10,000. Asking for favors, maybe a GoFundMe, I don't know, that's pretty cool. Your parents, that's probably the first thing you're gonna turn to is, Ask mom and dad, maybe they could help me out. I made that perfectly clear with my kids. If any of them ever found themselves in jail, do not call me. You got yourself in, you're gonna get yourself out. I will not post bail for you, period. I'll be there to support you. I'll be there for all your court dates. But I'm not bailing your ass out. Thank God they never called me. None of them ever got in trouble. One of my nieces did. She found herself in a jam and she's sitting in jail. So my aunt calls. She goes, what should I do? I said, leave her there. It was like Friday night. First thing Monday, they're gonna hear her case and she'll be out. Don't worry about it. She goes, well, okay. Hangs up, calls my dad. He gives her the money. She goes down and bails her kid out. But why is she wasting my time calling, asking for advice? And she did okay. She just got, everybody makes mistakes, guys. But damn it, when you're posting bail, that's a lot of money. Whether it's $100, $1,000, or $10,000, that's a lot of money. So be careful about that. Okay, so cruel and unusual and excessive bail. We just determined that between 100 and 10,000 is the leeway of what we consider excessive. That's just our opinion of what excessive is. Now we gotta think, what is the court gonna think excessive is? What's a third party gonna think excessive is? It's too vague is the bottom line. I wish they would have done a little better job when they wrote that, instead of saying excessive bail.
I had never been in trouble before, first time,
Yeah.
and my bail was $1 million, but I think in my case, the excessive would have been $3 million.
So you think $1 million was fair?
Well, for the court,
For the
that's
court,
that's
yeah.
what they would have seen, if they would have charged me a $3 million bill,
Yeah.
the court probably would have thought it was excessive, but $1 million bill, coming all day long.
They thought that's okay, right?
I mean, first, yeah.
Yeah, so for $1 million, if I'm a bondsman, I want 100.
Yeah.
I want 100,000 up front. I'm not letting you out any cheaper than that.
My dad would have to sign his house, and
Exactly.
then even if I got out, missed one court date, they would take it all.
It's all gone. Yeah, complete. Even if it's an honest mistake, you're out. The court does not mess around. Who wants to go into law school? Be an attorney of any sort? 1, 2, good. So 2, maybe 3. Somebody's a little shy. 3. When you get to law school, you have to submit assignments on time. Okay, they want to program you, because if you're going to be an attorney and the court says, I want your brief, the judge, I want your briefs in my office no later than 12 o'clock Friday. How they secure that time is you have to present your brief at the clerk's window. They stamp it, time stamp. If it's 12:01 on that brief on Friday, it goes straight in the garbage. You just missed your deadline. There is no forgiveness. Can I have an extension? They don't give a damn. So when you get to law school, all your papers you're going to be submitting are time stamped. If you submit a hard copy, I remember we used to have to go up to the front desk. They just have their clock sitting right there. Come deadline, there's a line of people standing there just stamping away, make sure they get their papers in on time. Then you put it in your instructor's basket. Get used to it, because if you're late, it goes in the round file. No excuses, none. Remember that. Forget everything else, remember that. Make sure you get your work in on time. Okay. Cruel and unusual. It's vague. I don't like it. Okay, although Stack versus Boyle did not establish an absolute right to bail, it did set guidelines for state courts to follow. If a crime is bailable, the amount should not be frivolous, unusual, or beyond a person's ability to pay it. What do you think? Do you agree? In what types of cases would you refuse bail? So the bail, and let's get some kind of a scenario. The defendant is accused, and that's a key word. They're accused of entering a home by force, unoccupied, and stolen electronics, jewelry, money, the sum of $35,000. Okay, that's the allegation. You're responsible to set bail. You're the judge. What amount of bail do you think is fair for this defendant? Little background on the defendant. This isn't the defendant's first time dealing with the law. They've been before the court multiple occasions for substance abuse issues. Never a property crime. First property crime, but they have been in for substance abuse issues. It's a male, 23, 24 years old, Hispanic, lives at home. That's the only residence on file, is still with the parents.
Do you have a job?
Unemployed. What are you gonna set bail at? You're the judge, come on.
35,000.
35,000, good number. E? What do you think? Give me a number. You get to be the judge.
20, since he's unemployed.
20, he's unemployed. Okay, so we got between 35 and 20. Does everybody agree with those numbers, that range?
When he has his 35 stole, right, so he can use it.
He has the things he stole. They were never recovered. So he should be able to have it.
Yeah, I would say higher than that.
With this scenario I gave you, and I'm guessing, because they have a schedule, and it's usually right in the booking room. I'm guessing something like that goes for at least 50 to 100,000. Is that excessive? Seems fair. 50, we'll go with the low number. At 10%, that's 5,000 to secure a bond. You can usually get one for about 3, maybe 3,500. That's not too bad. Something like that seems doable. But now let's say, instead of this guy living at home, he is a repeat offender. He's just been released from custody within the last 90 days from the state prison for property crimes and substance abuse. He has 2 strikes on him right now. Are we still gonna let him out at $35,000 bail, or even 50,000? I see one hand.
What I would do is I would do like a scaling thing. I would say, hey, look, okay, the total amount of crime is 30,000. First offense, because it's not escalating pattern, I would do 1.5, 100% of that plus 0.5, so it'd be 30,000 plus for bail. The second offense, I would probably double it, 300% or whatever. So if he took 30,000, the second offense, I'd probably charge him, more than that.
So you're basing it on the factors?
I would just do it at a percentage scale on the
Okay.
basis of the person that had an escalating risk, threat to society.
So where's your final number? Where do you come up at?
With the second offense, I would say like 90,000.
He's already got 2.
I would say 90,000. If
So
he
about
stole
90.
30,000 at the second time, I would say 90,000.
Okay. About 90.
Three times, 1, 2, 3.
Okay. Anybody disagree? You gonna go a little higher, be a little more strict with bail? What do you think?
Probably would have done more like 200,000.
About 200, okay.
Yeah.
He's got 2 strikes on him.
Make it more difficult for him, because if you're just repeating so many times, it's like, when are you gonna learn the lesson?
Normally the sweeten the pot. During his first 2 priors, he has a couple of failure to appears. Yeah, right?
300.
300. See, these are the things, the factors the court has to take into consideration. What's the likelihood? Remember, he has 2 strikes. If found guilty, he's done. In California, 3 strikes, he's out. He's looking at life in prison. He's already got failures to appear. The chances of this person even being released are remote. And if there is a chance, that bail's gonna be at about $1 million. Okay, that's how bail works, guys. We're looking at the risk. And based on the risk determines how we're gonna approach bail. Okay? Keep that in mind. That's how bail works. Alternative bail release mechanisms. These are options the arresting agency has instead of just bail. It's just straight bail. Cite and release. Very common. Very common. Especially low offense felonies and just about every misdemeanor. It's just gonna be a cite and release. Police station's citation release. You get notice that the cops are looking for you. They think you were involved in something. So you go to the police station and say, hey, I heard Officer so-and-so is questioning people, asking about my involvement in a case. I'm here. They're gonna pull you in the back, talk to you, most likely let you go. Cite you and say, I need to talk to you again. Make yourself available. Give me a good number where I can get a hold of you. Police pretrial, jail citation and release. Now you're at your pretrial, at the arraignment. And the arresting officer's there saying, I know this person. I'm fine. He doesn't need to be in jail. 100% persuasive, most likely that court's gonna let that person go out on the warrant. Direct release. The judge looks at the factors and says, instead of, let's see, pretrial, okay. Maybe it's a lot, they do a lot of this stuff in drug court, when talking about substance abuse. They don't want you sitting in jail. They'd rather you go to a different place where you can get treatment. That's the good part. The bad part, it's up to you to find that place. They'll give you, I don't know, usually a couple of weeks. Oh, I remember hearing this in court. The defendant gets up, Your Honor, I found a place at such and such rehab. They said I could have that space, but I'm trying to get the money, because you gotta pay for it. I'm trying to get the money to get in. The judge is gonna say, okay, come back in 2 weeks, let me know your progress. Boom. Kid comes back, says, I got it secured, I got the money, and I'm asking to be allowed to participate in this program. Most likely they're gonna let you do it. Instead of sitting in jail. Okay, we kind of touched on the types of bail. Money, all cash. A deposit, you put some on it. Okay, a little bit on it, on what the total is. A surety bond is like an insurance. You're still buying, whether it's through a bondsman or you have other means to secure it. Conditional bail, unsecured bond, and then release on your own recognizance. Conditional, as long as you show up for this, as long as you refrain from this, as long as you don't associate with these people. They put conditions on how they're going to release you. They're all better than just being kept in jail. And this is the way it's used. Was that 90? The surety bond is almost 50%. Secured, that's your bondsman. Your OR, conditional deposit, full cash, property, emergency. We didn't talk about that one. You're standing before the court. Your wife's at the hospital, getting ready to give birth. Or your parent, one of your parents is sitting in the hospital almost ready to die. These issues have to be presented to the court, and it's up to the judge. But they do let people go to these types of things. And you can see it doesn't happen that often. Most serious arrests. This is one example of a schedule, a bail schedule. Available 96.9. Violent offense, murder, $1 million for a murder. You think that's excessive? No, I don't think anybody would think that's excessive. Depends on the murder, right?
Well, I think prosecutors routinely engage in overcharging. So,
That's why they have a bail hearing, right? You had a hearing? You didn't get a hearing? No.
I never went to arraignment.
Oh.
I mean, I went to arraignment, I never went to preliminary hearing.
Because of whatever your deal was.
Yeah, the prosecution offered me a deal before I went to prelim, never been in trouble, didn't know. Had I went to prelim, chances on a 995 motion to dismiss, everything would have been dismissed.
Yeah, good attorney. Yeah. Ineffective assistance of counsel. Depends on the murder. If it was a passion of crime, a crime of passion, say that.
Keep
A
that.
crime of passion, yeah. Heat of the moment. You might get $1 million bail because the risk, again, is minimal. But what if you're a suspect in multiple murders? You ain't gonna see them that day. They'll hold you without bail. And they can do that. Because we want to make sure we get this bad person off the streets, make our community safe. Okay, so that gives you a little glimpse of what bails look like. Driving.
The top numbers, like retain, release, total,
Mhm.
what was
Not sure. The total is what they're charging you. I get the first
I
column.
think it's average.
that?
For here?
Yeah, because I'm thinking if you're detained, it jumps
I
like.
think if you add all those numbers and divide it by the end, that's what the number would probably come down to have.
No idea. It's in your books. It's, well, that's where I got the information. Maybe it'll explain the table a little better. I just put it up there to give you an idea of what a scale looks like. Okay, pretrial detainees. People who are either detained on bail or cannot afford to post bail before trial. You're kept in jail. Okay, so if the judge doesn't want to release you on OR or any other type of conditions, they insist on bail being met. And you cannot afford the bail, you're staying in jail. More likely to be convicted, get longer sentences than those who commit similar crimes but are released on bail. Isn't that something? So if you and another person, similar circumstances, but you can afford bail and the other person cannot, the person that has to stay in jail is going to get a harsher sentence. Is that fair? Of course not. But it's a stigma. You're standing before the court in that orange jumpsuit with waist chains on, answering to the allegation. And the other person shows up. Usually they put on a tie all the time. I don't know why, but they put on a tie and they're standing there, yes, Your Honor, meek as a mouse. The court is influenced. And the sentences are not equal. Not fair, but that's the way it is. Bail has been heavily criticized as one of the most unacceptable aspects of the criminal justice system. There has been, I think one was called the Manhattan Bail Reform Project, but people have tried to come up with a better system. So bail reform has resulted in the use of release on OR to replace money bail for non-dangerous offenders. Also efforts to tighten bail restrictions on the most dangerous offenders. As a society, we agree violent offenders that are going to hurt people should be kept in jail. I don't think anybody's going to disagree with that. Anyone want to disagree? We have a violent offender. Should they be let go? Probably not. On the other side of the coin, you have this one person here, did something stupid, made a mistake. The chances of them doing that again are slim to none. They should be out, released.
It boils down to addressing the causative factors that led to the incarceration, and I think it's the state's duty to provide a decent sort
lot of private enterprises that are trying to get involved.
So like,
In
for
reforming
example,
that.
I know a lot of lifers have been down since 1980s, they're still in prison to this day, they've been since 16 years old. And, every time they go to board, there's some evidence that they're a threat to society because they have not addressed the causative factors at level of incarceration. However, the institutions that they're constantly housed at don't have the programs.
So what are we gonna do? Bad guys stay in jail, right? They're not, or prison, they're not going anywhere, because they don't have the programs for reform.
He's like 65 years old.
Well, I've met some in my day. We're talking about reform. Who believes people can change? Okay, good. Most of you, people can change. I've only seen one. One person. He was a lifer, in for murder. And I know it may sound stupid, hell of a nice guy. Hell of a nice guy. He ended up getting out, never returned to prison again, living a normal life. He was found guilty, admitted his guilt. It was a crime of passion, and he killed his girlfriend. He did his time, didn't run, stood up, guilty. This is exactly what happened. 25 to life, he goes to the board, gets a release date, he gets out. God, he's paroled, I want to say like 86, 87. Never been back. One. I bet thousands of individuals that said they were reformed. Some even found Christ, believe in God now. The minute they get back into the street, they revert right back to what they did before. Most committed more egregious crimes than they were first imprisoned for. That's the ugly truth. That's the cycle. People can change. I'm not going to say they can't. They can. I'm just saying I haven't seen it, except for the one. And it's sad. Reform, rehabilitation, providing programs. There's that saying, you can lead a horse to water. Right? Sure. And sometimes the state doesn't even do that. True. They don't even provide them with these resources. It's not the best system in the world, but it's what we have.
I've heard in some of those incarceration shows, you know, how they have people like for their crime. A lot of the people don't, even though these programs could be offered to them, they don't want them, especially like gang members. So like, we want life in prison because we have it made here, and then why would we want to go back to society?
Yeah.
And it's their choice, and they oppose to even want to be part of
They
the
want
program.
nothing to do with it. So, don't know what the answers are. I'm just telling you what my lifetime experiences have been and my personal observations. And I hope and pray to God that changes for you guys. And that you do see people that change and reform and do something with their lives, because it's a waste. That's all prison is a waste of humanity. Programs that provide a number of services to those released into the community prior to their trial dates. Okay? There's programs to determine which defendants can safely be released on bail pending trial. What's it called? Pre-sentence investigation report. The PSI, probation does it. You guys should have read about that one already. It's just a fact-finding information so the judge can make a good determination. Assesses likelihood of failures to appear, provides supervision for defendants, and so forth. Okay, we're going to get into charging the defendant, so I'm going to stop here. I wanted just to get through the thing. Questions about anything we talked about? Opinions? No? Okay, hold on. You got something?
Oh, I wanted to say that I've seen multiple people like really cheat. There was actually so at my church we do like a shower. This is a cool story, so I just wanted to share it. We do like a shower ministry for the homeless people. Like they come in and get showers, right? So there was this one guy that always kept coming in, and he was actually a former like part of the game, right? So he was always in and out of jail and time and stuff.
Uh-huh.
And one of our pastors was actually a former, like gang member, and they were rival gangs, right? So
Listen
actually.
up, guys. Go ahead.
Oh yeah, so pretty much just the guy who was like homeless and a former inmaker, like he ran into the pastor who he literally like they would remember like literally pointing guns at each other like one
Yeah.
like wanting to kill each other, right? And then one having like such a different like now the pastor guy, he's obviously married and he has like 6 kids, beautiful kids, and he like when he saw that guy, the homeless guy, his name is Fred, he was like, oh shoot, like all the memories came back to him of like that was my former life, but now you know he's changed. And this guy Freddie, you know I've been witnessing to him. I don't go anymore, but and he's starting to have like a change in heart too, where you know he just sees it like you do, like it's such a waste of time, like the people he used to look up to, now he's like, like I don't know why I ever did that, you know. But they're like in their 50s now, 40s, 50s, yeah. So, but I wanted to say that, and then also the guy that I told you about the testimony, like he had 20 years, and then they changed it to 10. Multiple people that like I've seen a great change in people.
Good.
Yeah,
So you got to witness one. I haven't had that privilege.
like 5.
So for one time.
Yeah.
Gabriel,
Yeah.